Morning, Ms. Kuhn, Ms. Hills.
Morning, Your Honor.
How's everyone this morning?
Doing well.
How are you?
Good. Just one moment, please.
Calling the matter of Jeremy Griffin versus Sarah Griffin.
For the record, this matter is before the court on the plaintiff's motion to list a marital home for sale and other temporary relief. This hearing is being conducted via Zoom. The President's attorney, Kimberly Kuhn, representing the plaintiff, Jeremy Griffin. Mr. Griffin appears to be present with Ms. Kuhn. In addition, attorney Christina Hills is present, representing the defendant, Sarah Griffin. Ms. Griffin is also present. Good morning, Mr. and Mrs. Griffin.
Morning, Your Honor.
The parties have conferred this morning with the front of the court. This is Ms. Brower, who has provided the court the following recommendation. The court notes that a mediation is scheduled with Mr. Walker on November 4th. Is that still on your books, Ms. Kuhn, Ms.
Yes.
Absolutely, Your Honor.
Right. Okay, wonderful. I appreciate you being proactive. The recommendation this morning is that the following marital bill shall be equally shared and split between the parties, namely the mortgage payment, the internet, utilities, any agreed upon extracurriculars for the minor children, minimum payments on credit cards, as well as groceries. The plaintiff husband shall pay his car payment, his car insurance, his and the children's phone bills, the Microsoft expense, his life insurance premium, as well as Netflix. The defendant wife shall pay her car payment, her car insurance, her life insurance premium, and her phone bill. The parties shall exchange funds through Venmo. The plaintiff's motion to list marital home shall be adjourned to November 4th with the pretrial previously scheduled. The parties agree to close their joint checking account tomorrow, October 31st, but no later than November 4th. That is the recommendation. Of course, the court will be available on later in the morning, early afternoon on November 4th. If there's any issues that the court needs to address, we can address at that time if they're not resolved during mediation. Ms. Kuhn, is this recommendation good with your client this morning?
For the most part, Your Honor, my client wants to move forward with contacting the realtor and getting the home sold, or at least listed for sale. The motion was filed in July. At the time that the motion was filed, Ms. Griffin did not have a job. She has not had a job for a long period of time. Ms. Griffin has not attempted to talk to a lender to see if she would even be able to secure financing for the home. I know that Sue Kajawa had recently told me with regard to a home that got listed that now is the time to get it listed. We're getting into the winter months. So we really, I mean, we've been very patient, Your Honor, and there's just really great concern that Ms. Griffin isn't going to be able to secure a lender, and to give her another 120 days to do that puts us in the dead of winter. And we really just want to get moving with getting the realtor at least contacted, getting the house listed. If Ms. Griffin is able to secure financing and wants to have the right to purchase it, if Ms. Kajawa secures a buyer, then, you know, she can do that. But we really want to get moving on it, Your Honor. My client's been really patient.
Understood. And we can address that if necessary on November 4th. Obviously, Ms. Hills understands your client's position, Ms. Kuhn. The court sees no harm in having Ms. Kajawa or some realtor come over, look at the home, and then suggest a list price to both parties. The court suggests that if Ms. Griffin wants a different realtor, maybe she can have the realtor of her choice come over and also take a look at the home with both parties present and suggest a list price. So that can be done between now and next week, if possible this weekend. Contact those realtors.
That's fine, Your Honor. My client fully expects to be able to secure refinancing for the home. We had discussed at the last mediation, Ms. Kuhn brought up the 120-day figure. That's what my client was sort of depending on at this point. She's got a great job now. She has been working on some other issues related to the divorce and hasn't had an opportunity yet to really delve into the refinancing, but she's got a good credit score. She's got a very good job with a good income. And yes, she did have a period of unemployment, but we don't expect that to be any impediment. But she's going to be looking into that today as well in advance of mediation on Monday.
Good. Is an appraisal of the home necessary? Can the parties agree upon its fair market value?
We had an appraisal in May, and I've contacted Mr. Sorrento to see if there have been any other homes comparables that have sold that would affect that value. So I have contacted the appraiser.
Do you have a copy of that appraisal, Ms. Hills?
Yes, I believe we can agree.
Hopefully the parties can agree during mediation, the fair market value for that home. So that issue can be addressed at that time. All right, anything further this morning, Ms. Kuhn or Ms. Hills?
No, Your Honor.
All right, the court will adopt the recommendation on a temporary basis, and we'll see everyone until further order of the court, and we'll see everyone on Monday, November 4th then.
Thank you,
All right.
Judge.
Thank you.
Thank you both. Have a good rest of the day.
You too.
Thank you, Ms. Brower. Good morning, Ms. Brower.
Good morning, Your
For the record, this matter is before the court subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn representing the plaintiff, Jeremy Griffin. Mr. Griffin appears to be present with Ms. Kuhn in her office. In addition, Attorney Christina Hills is present representing the defendant, Sarah Griffin, and Ms. Griffin is also present. Good morning, everyone.
Morning, Your Honor.
Morning.
The court has been informed the parties have made progress and reached an agreement this morning. Is that correct?
Yes, Your Honor.
Wonderful. Who would like to place that agreement on the record?
I can do that, Your Honor.
Kuhn?
Yes, thank you.
Okay.
Your Honor, the agreement is as follows. The parties are going to share joint legal and joint physical custody of their 3 children, Landon, Marshall, and Olivia. The parenting time arrangement is as follows. Mother will exercise Monday to Wednesday. Father will exercise Wednesday to Friday, and the parties will alternate weekends, and the weekend is defined as Friday to Monday. The exchange time will be at 4:30 p.m. The exchange will be at father's home for mother. However, if mother is coaching, the parties will agree to a later pickup time for mother not to exceed 7 p.m. So long as father lives in Monroe, if there's no school, then father will be picking up at, hold on one second. If there's no school, actually the exchange time is going to be 4:30 p.m. Transportation is at the beginning of parenting time, and if either party move out of Monroe County, it would be at a agreed upon halfway point. The paternal grandparents' home will be the bus stop, so long as the kids are still in the Monroe School District. The parties do agree that the kids will remain in the Monroe School District. The only issue would be is if both parties moved out, but I talked to my client about that, so he knows he needs to stay. Parties will communicate with each other and not through the children. No third party will take the kids for any medical treatment unless it's an emergency. Parties will cooperate in allowing the children to do what is necessary to be confirmed at St. Mary's Church. Parties shall have 2 non-consecutive weeks of vacation taken on that parent's already scheduled weekend. Holidays will be as agreed or pursuant to the front of the court holiday schedule. As I stated, the kids remain in Monroe Public Schools unless otherwise agreed. There's no alcohol consumption during the parents' parenting time. Spousal support is barred. Child support, the parties are earning about the same income, so there's going to be no child support. Mother shall be responsible for providing the health insurance for the minor children. Any uninsured medical bills would be equally shared by the parties. Tax exemptions, each party will have 1 tax exemption. They're going to alternate the 3rd child with wife receiving the 3rd child in odd years, husband in even years. When there's 2 children remaining, they'll each have 1 exemption. And when there's 1 child remaining, they'll alternate. Wife would claim in odd years, husband in even years. Each party is awarded their own life insurance policies, free and clear of any claims of the other. They're each awarded their own vehicle. My client has to make timely payments on his vehicle. I believe that the loan is in his wife's name. Each shall be responsible for their own marital debt, including any medical bills and credit card debt. However, they shall equally divide. There was a medical bill for Olivia. It was approximately $2,887 at our last mediation, and there was one for $54. Whatever the balances are, if they've been paid down, the parties will equally divide what's remaining. My client is to pay his wife $7,000 to equalize the marital share of the debt for the parties' credit cards. The 7,000 will come from husband's proceeds from the marital home. There's an anti-bankruptcy clause. She can't file on her credit card debt since he's paying her the $7,000. Each will pay 50% of any agreed upon extracurricular activities for the children. Parties represent that they're able to divide their personal property to their mutual satisfaction. However, in the event that they're not able to do so, the parties will submit to a binding arbitration with William Godfrey. Each will pay 50% of that arbitration. No lawyers will be included. The kids, there are bank accounts. They're each awarded their own bank accounts, free and clear of any claims for the other. I believe Sarah is on the kids' accounts. Those accounts are awarded to her for the benefit of the children. There was a joint account. That account has been closed, so that has been taken care of. There is a pension that wife has. My client is awarded the marital share of the pension. It would be valued from date of marriage to date of divorce. My client can elect single life annuity based on the alternate pays lifetime. If he so chooses, he would also be entitled to any other benefit conferred by statute or the plan as well. There's a National Heritage 401k. Again, the date of valuation will be date of marriage to date of divorce. There was a loan on that account, and the parties agreed that $10,815 of that loan will be added back in for the division of that account. The marital bills are going to be status quo until the house is sold. There was a agreement with regard to monies owed to my client's parents and money that Sarah was requesting. Those are going to be a wash. So the house is going to be listed with Sukhajawa as soon as possible. The party shall follow all realtors' recommendations. However, if there's any maintenance or repairs, both would have to agree to the cost of the repair unless the other person wants to do it at their cost, to which then they would pay for that total cost of the repair. And as I stated, status quo with regard to the payment of the marital bills until the parties vacate the home. Obviously, they would each be responsible for their own credit card debt. I would say probably now, right, Christina? They should probably start paying their own credit card debt.
Yeah, I think that makes sense.
Okay, and then what about their own cell phone bills? I don't know if they have joint account for cell phone bills.
We already divided those up last week.
Perfect. And then and we did vehicle insurance already, so perfect. So that, yeah, what we did last week would then that would be our status quo.
And that would be until closing, correct?
Until closing, yeah.
On the house.
Until closing and the parties vacate, because if there's still bills for electric and all of that, I would say until closing and they vacate.
Okay.
That's all I have, Christina. Did I miss anything?
Judge, we would include the standard inherent rights of the children language as well as a prohibition on disparaging remarks or discussion of the case. I believe we had agreed to at least 30 days notice of the 2 non-consecutive weeks of uninterrupted parenting time. And I had in my notes that father would have priority in odd years and mother in even years in the event of a conflict in the dates that they've requested.
Ms. Coon, is that agreeable?
Yep.
Okay.
Okay.
I thought I heard, and I could have heard it incorrectly, that Ms. Kuhn said that her client was awarded the marital share of the of my client's pension. I just wanted to clarify or confirm that that's 50% of the marital portion of her pension, as well as him getting 50% of the marital share of her getting 50% of the marital share of his 401k, and the extra benefits that he may be entitled to under her pension would be his proportionate share.
Correct.
And I just wanted to clarify the tax exemption language. I thought I heard mom gets the third child in even years, but then when there's only one that she got the child in odd years. So I just want that to be consistent. That if she has the extra child in even years when there are three, that she would have the one child in even years when there's only one
I had wife odd years, father even years.
for both.
So I kept it just odd for,
Okay.
yeah, when the last one, mother would have odd years, father would have even years. It would stay the same.
Okay, all right. Thank you. I did not ask my client, I believe she's asking for the opportunity to have her maiden name restored if she chooses. Is that correct, Sarah? So we would ask that be included. I believe otherwise that is the entire agreement.
Thank you, Ms. Sills. Ms. Kuhn, are those clarifications acceptable?
Yes.
Well,
One
wonderful.
more, sorry, Judge.
Go ahead, Ms. Sills.
They can only take their own weekend for purposes of the summer parenting time. They cannot tack on the other party's weekend.
I said that.
2 weeks, okay. All right,
Yep, I
thanks.
said that.
Great.
Right, wonderful. Mr. and Mrs. Griffin, can you both please raise your right hand to be sworn, please? Thank you. The court will note the proofs were taken, Ms. Kuhn, back on July 8th. We simply need to confirm through Ms. Sills that Ms. Griffin is not currently pregnant, but if you could simply make inquiry of Mr. Griffin as to his understanding of this agreement, please.
Yes. Jeremy, can you state your name for the record?
Jeremy Michael Griffin.
Jeremy, you heard the agreement that was placed on the record, correct?
Yes.
Do you understand all the terms and conditions of this agreement?
Yes.
Do you have any questions with regard to any of the agreement that was placed on the record?
No questions.
So you understand everything?
Yes.
Is it fair that you and I have had an opportunity to discuss all of these terms and conditions that comprise this agreement, and you've had enough time to think about the agreement? I've been able to answer your questions, and there were no surprises coming in today.
Yes.
And you understand that had we gone to a final hearing on this matter, the result could have been the same. It could have been different. You understand that,
Yes.
correct? Notwithstanding that fact, you're waiving your right to have a final hearing, and you're asking the court to adopt the agreement that was placed on the record, correct?
Yes.
You understand that you and your wife need to get a hold of Sue Kajawa immediately to get that house listed. You understand also that you're going to follow her recommendations.
Yes.
So with regard to the recommendation regarding the price of the home, you're going to follow her recommendations.
Yes.
You understand that any maintenance would be paid by both of you if you agree, but if you voluntarily undertake some type of maintenance of the home, that would be at your own cost.
Yes.
You understand that?
Yes.
Okay. Are you satisfied with my advice and counsel?
Yes.
Anyone threaten you, coerce you, or otherwise induce you into entering into this agreement?
No.
There's no side deals, correct?
No.
Are you asking the court to adopt this agreement and make it an order of the court?
Yes.
Okay. No further questions, Judge.
Thank you, Ms. Kuhn. Ms. Hills, do you have any questions of Mr. Griffin first?
None of Mr. Griffin, Your Honor. A quick inquiry of Ms. Kuhn based on a text that I had sent her right before we came here, and that is in regard to potentially holding the judgment until just after the first of the year for tax purposes.
Would the two of you like to file taxes together? Would it be beneficial?
What do you think?
Usually,
Yeah.
it is. So what we can do is we can delay entry of the judgment until January 1st.
Okay.
This would still be in effect. So we would still, we can still, do we want to do then, with the 401ks, I guess we can wait till January. Are you okay with all of that? Just waiting until, okay, just value it then, I'm fine with that.
Yeah.
Okay. So if we delay entry then, are you on your wife's health insurance too?
No.
Okay, so you have your own health insurance. Okay.
So
And then
it's
you'll
agreement
file
the
a
judgment will be submitted for entry after January 1st, is that correct?
Yeah, and then the parties will then file married filing joint. and then they'll split the refund.
The date of valuation of the marital portion of the retirement plans will be when?
It'll be when you sign it, so it's gonna be date of marriage until we get the judgment in, which
Okay.
is fine. With the election year, I'm almost afraid to do anything right now, to be honest, Judge.
Okay, and now the quote will certainly be available the first week of January, so that can be signed on January 2nd, or as soon as the court receives it after January 1st. So, and that's all agreeable, Ms. Hills?
I had spoken with my client about that at the end of the mediation, and at the time that was agreeable to her. Is that still agreeable, Sarah?
Yes.
So I'm assuming that if they're finally married, finally joint, they'll split the refund and each be 50% responsible for any deficiency.
Yes.
Okay.
Well, Ms. Hills, any questions of Mr. Griffin?
No, Your Honor. Thank you.
Questions for Ms. Griffin, please?
Yes. Ms. Griffin, would you state your name for the record, please?
Sarah Elizabeth Griffin?
Are you pregnant?
No.
Have you heard all of the terms of the agreement, which have been placed on record this morning?
Yes.
Do you understand all of those terms?
Yes.
Do you believe that that agreement covers everything that was discussed in mediation?
Yes.
Do you have any questions about any of the settlement terms?
No.
Have you had enough time to think about all of these issues?
Yes.
Is anyone forcing you, threatening you, or coercing you into entering into this agreement?
No.
You understand spousal support, also known as alimony, is barred as to both of you?
Yes.
And that means neither one of you could come into court in the future and ask for it,
Yes.
right? Are you asking the court to grant you a divorce and adopt the terms of the settlement agreement as your judgment?
Yes.
And you understand you could have had a trial. We could have presented all of these issues to the court and let the judge make all of the decisions.
Yes.
You might have done better, you might have done worse, or the judge could have ordered something substantially similar to what you've agreed to. Do you understand that?
Yes.
By entering into this agreement, there will be no trial.
Yes.
You're satisfied with my services on your behalf?
Yes.
And just to ask it one more time, are you okay with delaying entry of the judgment so that you and Mr. Griffin can file your taxes together for 2024?
Yes.
Based on past history, you believe that will be beneficial to both of you and the children?
Yes.
Thank you. I have no further questions.
Ms. Kuhn, do you have any questions, Ms. Griffin?
Actually, Your Honor, I just noticed that I did not put something on the record. I want to make sure that the parties understand that they're each going to get 50% of the net proceeds derived from the sale of the home after the costs associated with the sale of the home are paid. I did not put that on the record, and I want to make sure that the parties understand that. Other than the $7,000 that Sarah will receive from my client to equalize the marital debt, they're each going to get 50% of the net proceeds. And I apologize, I just noticed that, so.
I'm sorry,
I just wanted
and I thought that had been mentioned when Ms. Kuhn brought up about the $7,000. My client would be getting 50% plus $7,000 as I understand it and had it in my notes.
Correct.
Okay, thank you for that clarification. And with respect to the joint tax return, the parties, will they share equally the expense of that preparation fee?
Yes.
Yes.
All right. Okay, very well. Okay, Ms. Kuhn, do you have any questions, Ms. Griffin?
Yes, Ms. Griffin, did you make a full disclosure of all of your assets and debts in this matter?
Yes.
Thank you. No other questions.
All right, then you'll prepare the judgment. Is that correct, Ms. Kuhn?
I will.
Thank you. Very well, the court would like to thank Mr. Walker for his assistance this morning in helping facilitate resolution, but particularly the court would like to acknowledge Ms. Kuhn and Ms. Hills for helping their clients reach their own resolution this morning. Mr. and Mrs. Griffin, the court would applaud the two of you for being able to co-parent your children. You were both assisted by very capable family law practitioners, and without question, the best resolution is one in which you participate as you have today and previously and reach your own agreement. So it's wonderful. And your children will benefit from that. And keep in mind, there will be challenges in the future as the children get older, but effective communication is the key. Again, based upon the testimony that's been presented today, as well as previously, as well as the complaint files, the court again finds their jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. Unfortunately, there appears to be no reasonable chance of reconciliation. Accordingly, upon receipt of the consent judgment in January of 2025, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from bonds of matrimony. Good luck to both of you, Mr. and Mrs. Griffin. Now conclude this hearing. You can both zoom out. Thank you again, Ms. Kuhn and Ms. Hills.
Thank you, Your
Thank
Honor.
you. Thank you,
You're
Mr.
welcome.
Walker.
Hi, Mayor William Morales versus Morales.
For the record, this matter is before the court on the objections to a referee recommended order filed by the defendant, Haley Morales. The matter was adjourned so that Mr. Morales could consult an attorney. In any event, this hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing Haley Morales. Ms. Morales appears to be present with Ms. Zagorski. In addition, William Morales is also present. Good morning, everyone.
Morning, Judge.
Parties have conferred this morning with Ms. Barr from the front of the court, who has provided the court with the following recommendation: that the referee recommended order be rescinded and canceled. The parties shall use app post for all communication. All appointments for the children shall be added to app post at the time the appointment is scheduled. Neither party shall discuss this case with the minor child, and no disparaging remarks by either parent toward the other parent, particularly in the presence of the minor child. That is a recommendation. Ms. Zagorski, is this recommendation good with your client this morning?
It is. Thank you, Judge.
Okay, Mr. Morales, good morning. Do you understand the recommendation?
I understand, but I don't agree with it.
Okay. Originally, you filed a motion to modify parenting time because your work hours changed, correct?
Exactly.
Okay.
I changed my complete lifestyle. I was working in a dispensary all the time. And now I literally work at GM where I work from 7 a.m. and get off at 3:30.
Okay, so what is your current work schedule?
My current work schedule is Monday through Friday, 7 a.m. till 3:30. And yet I have asked for more time, and I keep getting told no. I just want to know why I cannot be a father to my kids when I want to be. I need more time with them. They need more time with their dad. It's being hung over my head for a little bit more money. It's just craziness to me.
All right. The two of the issues that were present in front of the court recommendation is that Brandon Clare shall not be present with the children, mother's boyfriend, Ms. Zagorski. Was that addressed during your discussions this morning with Ms. Brower?
Yes, my client got a PPO. So Mr. Clare is gone. She solved that problem.
Well, the PPO does not prohibit Ms. Morales from inviting him back.
Exactly.
That should be addressed in any order. And obviously, if dad's right now, the current parenting time order seems like it's chopped up. The children are moved back and forth, back and forth. The recommendation seems reasonable that dad shall have the weekends, Friday after school, because he's home, Friday after school, 5 p.m. to Sunday, 7 p.m. What is unreasonable about the federal court recommendation, Ms. Zagorski?
Well, my client also works Monday through Friday, Judge, and Mr. Morales in his motion raises issues that predate the judgment of divorce. The issue that he raises that occurred after the judgment was entered is the Mr. Clare issue. And Mr. Clare, like I said, is the subject of a PPO. My client doesn't want anything to do with Mr. Clare.
Right. Understand. We're going to address that in this order because the PPO does not prevent Ms. Morales from inviting him over for dinner, because there's one day I see these too often. People on PPO and I'll say, well, we're getting along now. He has apologized and so forth. So we'll address that, Ms. Zagorski, in this order that Brandon Clare shall not be present with the children, but dad's new job occurred prior to the last parenting term, entered.
Yeah, Judge, and listen, I don't have any problem scheduling a mediation so that these parents can talk about the issues, but quite frankly, Mr. Morales has called the sheriff's department. He's called CPS on my client. He calls her a whore in front of the children. They tried the every other weekend over the summer, and Mr. Morales would say, well, I don't want to take this one to that birthday party, so you have to do it and I'll keep these two. He doesn't understand the rules of co-parenting. So if you want us to have a mediation so we can talk about what that looks like and how that works, I am more than willing to do that. But just out of the gate, to say that Mr. Morales should have every other weekend when he, first of all, hasn't carried his burden of proof. And second of all, we've tried it and it's failed. And third, he is absolutely vile to my client on a regular basis. That's not going to work for these kids and it's not going to work for my client.
All right. So they're all valid points, Ms. Zagorski. Mr. Morales, when did you start this new job?
Yes, sir. I started about 7 months ago at GM.
And just today, Judge, I asked him if we could refer the case to the front of the court for a modification of child support, since he acknowledges that he changed jobs. He didn't notify the court in writing, and he said no. So I have to file a motion. That's what we're dealing with.
I had to file a motion for my parenting time. I'm just trying to be a dad. I had to file that. So understand me there.
Well, Mr. Rouse, you are required to keep the front of the court informed of any change of employment. So yes,
I
obviously,
understand that
support
now,
is subject
sir.
to
I
modification.
do really apologize for not being able to for not doing that. I thought me in the last hearing, if you will, I thought that was me doing that by letting you guys know that I got a new job. I wasn't aware that I had to go deeper and put it in writing. That's my fault.
Okay, so your divorce was entered in May of this year. You were
Yes, sir.
employed by Jim at that time. Why didn't you address parenting time at that time?
I honestly, I didn't know that I had to right away. And I could have sworn when we were in the middle of me leaving the other job and going into this, we had a hearing and I said it there too, that I'm starting at GM. I got a new job in line and everything. I thought it was me. I thought that was okay. And that was taken care of on that end. But I understand that now I have to put it in writing. I'm right around the corner from the courthouse. I thought we were in person today. So I came there. So right after we get off of this call, I'll come right there and give you guys it in writing. No problem.
Right now, your parenting time is every Tuesday afternoon to Wednesday morning. You have the children overnight on Tuesday nights.
Yes, sir. I have all right. So my
well
parenting time works Sunday from 12 to 6. Lately we've had football, so that's really kind of interacted with that. Football gets done around 3:00, but it is the end of the season. It gets done at 3:00, and so I would keep the kids till 6. So that's a total of 3 hours right there with the extracurricular activity. On Mondays, I would then pick up the kids from school, and then I would take my daughter to gymnastics with all the kids, which would take an hour and a half out of my time with them, and I only keep them until 6. So that's 3 till 6 again. On Tuesday, I do get my overnight with them. I keep them after school, which we did have football practice till about 7:30, which now that's not the problem. Now I get to keep them overnight until the next morning and drop them off at school.
But Mr. Rouse, extracurriculars are important for the children,
100%.
whether it's gymnastics or whether it's a birthday party, and that's things you as a parent should enjoy with your children.
Exactly.
You should go to the practices and watch your children participate, whether it's football or gymnastics. So don't say, I'm losing my parenting time by taking them to these activities.
I get that.
You're looking
I get
at the
that.
wrong way, Mr. Morales.
I'm sorry. And I didn't mean it I'm losing my time with them. I'm just saying I'm not getting a lot of that one-on-one time with my children, in our home front, if you will. I feel like a lot of me is just doing the run around because that's
part of being a parent, Mr. Morales. That's part of being a parent.
With that. I'm okay with that, sir.
Hold on. You should support those activities. Mr. Morales, did we lose you? It appears we lost him. Give him a few minutes, see if he can reconnect. All right, Mr. Morales, can you hear the court?
Yes, I can. I'm so sorry about that. My phone died.
That's right. We waited to reconnect.
I appreciate you guys. Sorry about that.
So those extracurricular activities are important, Mr. Morales, and you should, for example, it's one-on-one time with your daughter if she's got gymnastics to take her there and ask her how things are going. And I don't know if they allow parents to observe, but those are important things as being a parent. Very well, Ms. Zagorski's suggestion makes a lot of sense, Mr. Morales, that the two of you mediate. Now, parenting time, but also child support. Child support needs to be addressed and modified. And the court, you're both here. The court does not want Haley to have to incur a filing fee, and both you have to come back to court on the issue of child support. Are you willing to meet with Haley and Ms. Zagorski to discuss parenting time modification as well as child support modification?
I'm willing to.
All right. Let's start on the recommendation. The court will not rescind the referee order at this time. I think there's some merit. The recommendation, of course, is every weekend. Mom should have some weekends, Mr. Morales. So maybe agree upon certain weekends. I mean, maybe the first, third, and fourth, or the first, second, fourth weekend of the month. So the children have some weekends with mom because it's in terms of school year. Maybe you need to have a different schedule for summertime, where you have more time with children during the summertime. But right now, your parenting time schedule seems like it's chopped up a lot. Children go back and forth. They should spend a little more time with dad. The court would agree, but we will add this recommendation is that the Brandon Claire shall not be present during mom's parenting time, which sounds like it's not going to be an issue. So we'll add that to this recommendation. Again, in the interim, all communication should be by app close. Load that app on your phone, Mr. Morales. If you have an appointment for the children, you need to put that in app close. Same with mom. And the children should not be involved in discussions. This is between the two of you as parents. You should not be discussing parenting time or these issues with your children. And don't make any disparaging remarks. Ms. Broward, do you have your availability as to mediation with these parties? We can put that right in the same order.
Yes, Your Honor.
And the court can simply, after the mediation, address these objections. So at this time, the court's not going to rescind the the referee recommend order. We're going to keep everything on the table, Mr. Morales.
Thank you.
Work schedule. You're home at, again, I obviously don't want to interfere with work schedules. Ms. Morales, I'm not sure what her work schedule is. Ms. Gorski, we try to work this around everyone's schedule. And maybe at work, you can always, if you have breaks, Mr. Morales, you can step out and you can go into a break room or your vehicle. Plan on a good hour to discuss these things. And there's no reason why you and Mr. Morales cannot talk about these things between the two of you. Two of you know what's best for your respective work schedules and that of the children, their activities.
You're absolutely right.
Encourage that.
You're absolutely right.
There's enough challenges in life. Don't make it more difficult. And obviously when there's stress and anxiety, the children sense that. They don't need that. Ms. Brown, do you have a mediation availability in terms of the near future?
I have availability on November 18th in the afternoon or November 21st.
Anything nothing in the mornings?
I have the 21st in the morning.
Okay, the court prefer morning. Ms. Zagorski, that's a Thursday morning. Your schedule and Ms. Morales' schedule?
That is my birthday, Judge, and
Oh.
my paralegal is insisting that I.
Okay, well, I gotta put that on my calendar because we ran into that before, so we don't want to interfere with your.
I can do the
21st of November.
22nd, if the 22nd is available in the morning.
I can do the 22nd.
Wonderful. What time, Ms. Brower?
I typically start at 8:30.
Okay, will that work, Mr. Morales, 8:30?
Yes, sir.
So Friday,
Yeah.
November 22nd.
Perfect.
Will that work for Ms. Morales?
It does,
Yes,
Judge.
sir.
All right, so we'll put in this order, the parties shall mediate the issues of parenting time and child support. With Ms. Brower, November 22nd, Friday, 8:30 a.m. Thank you, Ms. Brower, for your availability. And that'll be by Zoom. Perhaps you can put in the order your Zoom ID number, Ms. Brower,
Yes, Your Honor.
please. Thank you. And the parties can Zoom into the court after the mediation. And if you don't have an agreement, the court will make a decision. But the court would encourage the two of you, if you can communicate as rational adults, the two of you to communicate in terms of what makes the most sense. Anything further, Mr. Zagorski, this morning?
No, thank you, Judge. Appreciate
You're
your.
welcome. Thank you. Mr. Morales, anything further? Do you have any questions?
I don't, but am I able to bring you this information that I have in regards to this case? Like I have like a file of some information for you, and then I was going to give it to Ms. Zagorski too.
Obviously, you need to provide this, Ms. Gorski. What information are you talking about?
It's a Child Protective Service investigation report and follow-up. It dates to. Yeah, let me check the date on the back of it. It is.
Well, you can provide that to the front of the court, Mr. Gorski.
Yeah, 9/13/2024. Yeah, I was just asking if I should just run this up to you real quick, like, because I'm right around the corner.
No, because we're not going to address anything. There's no motion before the court to terminate or modify mom's parenting time. So who made the complaint?
He did.
I did.
What's the nature of your complaint, Mr. Morales? Are the children in danger? Is mom abusing the children?
It wasn't quite abuse. It was exactly the danger that the children were basically in, if you will, with being around the violence all the time.
Okay, you talk about this Brandon Claire?
Exactly.
Okay, well, we've addressed that. Ms. Morales indicates that there's a PPO in place that prohibits Mr. Claire from having contact with her, and the court's putting in this order today that Brandon Claire should not be present during mom's time with the children.
Okay.
Yeah, and I would invite Mr. Morales to come to mediation, not trying to sabotage mom.
Yeah. So let's keep an open mind. Mr. Morales said, again, obviously, if Protective Services was concerned, they would have taken action by now. They would have taken in and they would have contacted the court and say, remove these children from mom. The fact that they've not done so indicates that they think it's no longer an issue. If you call them, I guess they probably already closed their file on the matter.
Okay.
So let's move forward. I mean, obviously, when things like that happen, you should always talk with the mother of your children.
I've tried, sir. I've tried.
Former wife and say, I've got concerns about this. The children, I'm concerned about their well-being. And then if she does not take action, then do what you have to do. But again, let's move forward in a positive, open mind fashion. So no, the court does not need that information, Mr. Morales.
Okay.
If you call CPS, I'm sure they'll tell you it's closed, done.
Okay.
All right. So Mr. Morales, don't forget you have to personally appear on Monday morning regarding your failure to pay a filing fee. If you want to, you're in the course today, you want to pay it today, come up with a receipt, and then you don't need to appear on Monday morning at 8:30.
Okay.
Because that was previously ordered. I'm just letting you know there's no, it's not an issue of argument.
I got you.
So if you want to, the court suggests you can pay that today, come up with a receipt, and then your personal appearance Monday morning is not necessary.
Okay.
All right, that will conclude this matter. We'll see everyone then after your mediation with Ms. Brower on November 22nd, 8:30.
Thank you, Judge.
Right, I'm going to zoom out. Have a good rest of the day. Thank you, Ms. Brower.
You're welcome, Your Honor. I'll have that new recommendation in your queue in just a moment.
Thank you. The primary issue at mediation was parenting time. Is that correct, Ms. Gorski?
That and we did raise the issue of child support. Mr. Morales changed jobs, didn't notify the front of the court back in May.
Okay. Have the parties been able to make any progress on their own resolution this morning?
I don't think so. I don't think that Mr. Morales is on board with our proposal.
Okay. And proposal as to parenting time or child support or both?
Both, sir.
Yeah, Ms. Brower did run child support this morning based on at least one of Mr. Morales's jobs. And my client's current income, Mr. Morales doesn't agree with that either.
Mr. Morales, so child support is pretty much based upon the simple math formulas. So if Mr. Brower made a recommendation, where did she make the error in terms of your income?
No, sir, I wasn't stating that there was an error or anything. The main thing on my end is like, I was told from another referee, like in the beginning, that they couldn't raise my child support just because I got a better job. That was just one thing.
That's wrong. If as incomes change up or down, support can be modified. If you break a leg and you're off work and you're laid off, yes, you're going to want a petition for a reduction in child support. So it's always subject to modification until these children attain the age of 18. So whoever told you that, it's incorrect.
Okay. And another thing too is like with seeking more parenting time, I was seeking more overnights, and so I kind of thought that would play in a factor as well.
It plays a small role in the child support calculation, the number of overnights.
Understood.
So, Ms. Zagorski, do we need an evidentiary hearing on this matter?
Apparently, I don't know what the court's going to do. Mr. Morales works midnights, Monday, Tuesday, Wednesday, Thursday overnight. So we tried to work out an agreement here where he could have every other weekend and an evening during the week from school and then bring the kids home because he has to go to work. I don't know exactly what he's looking for given his work schedule.
Was this discussed in mediation?
At length.
That question posed? All right, Mr. Morales, you can represent yourself, can hire an attorney. What do you want to do on this matter?
I'd like to seek representation, please.
Okay. The court has delayed addressing the front of the court referee recommend order. Is that correct?
Correct.
Mrs. Brower, there's a de novo hearing, and the court simply continuing back to today's date so the parties could mediate. That's the court's recollection. Is that your recollection, Ms. Zagorski?
Yes.
Okay, and the referee recommend order was that father shall have parenting time every weekend from Friday after school or 5 p.m. if no school to Sunday 7 p.m.
Correct.
6:30. I think it was the kids go to bed at 7:30. My client thought it was 6:30. However, she didn't receive notice of that hearing and didn't participate.
Okay, so it was Ms. Morales that filed the objection then, correct?
Yes.
Correct.
And at the same time, Mr. Morales filed the motion to modify parenting time since he has a new job.
Yes, sir.
And again, I don't know what your work hours are, Mr. Morales. The purpose of this was for the two of you to discuss your schedules.
100%.
And children, what's best for the children. And if the two of you cannot agree, then the court would schedule an evidentiary hearing and take testimony. I mean, it's pretty simple. I mean, Mr. Morales, if you want this court to drive the bus, it can do that. But really, it's very simple. You look at your work schedule, you look at mom's work schedule, you look at the schedules of the children, and decide what's best for the children.
Definitely.
It's a shame if you cannot do that.
Definitely. To be honest, sir, I just feel like I deserve a little bit more time as well. I like with the weekends, but I also could do overnights in the weeks as well. I have a babysitter that I would be able to have for the hours.
We're not just babysitters. We want to know that children spend time with mom and dad. And again, there's more flexibility in the summertime. When children are in school, they need to have a continuity. We're not going to break up the middle of the week when they have to be on a regular schedule for school, particularly 8 and 7-year-old.
Definitely.
There's more flexibility in summertime. So you can talk about summertime to be more flexibility with that because they're not in school.
Yeah. And after our first motion, I kind of expected that coming into the summertime and it never happened. So that's exactly what kind of led me to file this motion to kind of get more time. Like I'm perfectly fine with every other weekend. I have the weekends off and I can even get every weekend off if it came to. But like I said, I would just and I don't care if it's an overnight or not. I just want more time in the middle of the week too. It doesn't just have to be one day. I love spending time with these kiddos.
Judge, my client works until 4 o'clock in Dundee, and the oldest child has gymnastics at 4:15. And she asked Mr. Morales if he would please have parenting time on Mondays to get his oldest to gymnastics. And his response was, that's now not how he wants to spend his time. He didn't want to be bothered. So that didn't work for him. I don't know what to do with him. He doesn't want to parent. My client has begged him to co-parent. She's asked him for help, and he says, no, it's not convenient to him.
Your Honor, may I speak for myself on that end?
Yes, obviously it's good to the children see that you're interested in their extracurriculars.
Definitely.
So, yes.
I absolutely love like going and participating in the gymnastics and doing everything with them. Like, don't get that wrong or don't get it twisted, please. Especially when spending time with my kids. I absolutely love spending time with them. We have a great time together.
So do you want
May I speak? Thank you. So on Mondays, my only regard is I am potentially moving to Toledo, Ohio. That would be in Point Place. With that being said, gymnastics would be 30 to 45 minutes from my destination. And then I would have to loop to Ida and then loop back. My only thing, and I have no problem. Like I said, I will do it and I will help, and I have no problem helping. And Haley already knows that herself. I don't have a problem helping. She may not tell you, but that's the truth. And so with that being said, I have no problem with helping here and there, but I just feel like that being forced onto me every Monday, that's a lot on not just me, it's a lot on the kids too, because I have 3 kids with me in the car. I have little Mia, who's 2 years old. I have Xavier, and then I'll have Peyton as well. Peyton's going to gymnastics, and Xavier and Mia are sitting there waiting in the lobby with me. So the reason I said that, and like I said, there's nothing against being a parent. I absolutely love this stuff. I just wanted kind of more of like a day where I can spend time with them and we could go do things, or we get them home, get their homework done individually, type of thing.
So
I have no problem with being a parent though. Please don't put that on my name.
So we offered Wednesday, and he didn't want that either. I don't know how to fix
I
it.
went with the Wednesday, ma'am. I went with Wednesday. I said I could do Wednesday and Thursday and every other weekend. I'm okay with that. I just don't want to have to be the one that's always doing the driving everywhere. And I already have been through this whole process. So I would just like a little help on that. And especially considering my child support's about to be taken up some, like, I just help me out here. You guys are draining me. Like, and I don't mean that with disrespect. I mean that with all respect. I'm trying to be able to be a parent too, buy clothes, buy shoes, buy them anything they need. It's not just Miss Morales. It's not, and it hasn't been this whole time. So I'm still doing everything I have to do. And even if that requires me picking up a few more hours and working extra hours for them, I do it all.
So Judge, we offered to meet him halfway, which is the Ellis Library on M50. My client's on Albin, just off of Lewis, and Mr. Morales currently lives in Monroe. So we were going to meet at Ellis Reference, which is halfway.
That's cool. I like that.
So,
Okay, Ms. Morales, you're the one out to choose and move farther away, so you can't complain about drive time. In any event, I've got in front of the court a bench warrant. Ray member handle right now. I've got somebody from the jail zooming in. 11:15. Ms. Zagorski can. I'd like you to talk to Ms. Morales a little bit further, and I'll take care of this bench warrant arraignment with the front of the court attorney. Then I'll be back with you. Somebody put you back to the breakout room. Ms. Morales, sounds like you're not that far off. The reality is parenting time can be adjusted anytime. Right? So you need to figure out what's best right now. November, December, January of 24 and 25. You can always you can always petition for modification in the future as the children get older. You want to be part of extracurriculars, but if the Mondays are too taxing and you can't watch a gymnastics, you're sticking out in a hallway waiting with other children. I understand. And maybe Wednesdays.
It's not that I have a
talk
problem.
about more about this in summertime, more flexibility. But I'm putting you in a breakout room. I'll be back with you.
thank you.
Ms. Brown, perhaps you can provide the court with a recommendation after talk with them. They might come back in terms of child support and parenting time.
Yes,
Please.
Your Honor.
Court apologizes for everything bunched up at the same time. We had a number of cases involved mediation this morning. So we're back on the record in this matter. And the parties are present, as well as Attorney Maria Zagorski. Have the parties been able to make any progress in the last 30 minutes, Ms. Zagorski?
Yes, I believe Ms. Brower has uploaded an agreement to your queue.
Thank you. All right, Mr. Morales, listen to this. The court did receive a recommendation from Ms. Brower, and if the court adopts this order, this recommendation will become an order of the court. The recommendation is that father, you, Mr. Morales, shall have parenting time on a 2-week rotation. Week 1 will be Wednesdays and Thursdays from school to 6:30 p.m. Week 2 will be Mondays and Wednesdays from school until 6:30 p.m. and Friday, 4:45 p.m. to Sunday at 6:30 p.m. The exchanges of the children shall take place at the Ellis Library, and both parties shall have the right to record the exchange. I would hope we won't have to do that, but this provides for that. You don't want to put the children in the middle of all this and record everything, but if in fact that's what you agreed to, then fine. Further, it's recommended the father shall ensure the children are fed on his weekdays prior to the exchanges at 6:30. With respect to child support, commencing December 1st, 2024, the plaintiff fellow shall pay child support in the amount of $1,171 for the support maintenance of the minor children. It's based upon 75 overnights for the defendant, 290 overnights for the plaintiff. Uninsured medical expenses shall be shared as follows: 60% paid by the plaintiff father, 40% by defendant mother. After, of course, the mother pays the first $454 per year. The party shall follow all recommendations of the children's therapist. Neither party should make any disparaging remarks about the other in the presence of children or discuss this case with the children. Finally, all appointments and activities for the children shall be added to the app close for the benefit of both parents. That is recommendation. Ms. Gorski, is this recommendation agreeable with your client this morning?
It is.
Mr. Morales, do you understand the recommendation?
Yes, sir.
Recommendation agreeable with you this morning?
Yes, sir. Also, we had in there that we can't be late. I just want to
Well,
make
that's
sure.
implied.
Okay,
It's a
I just want to make
courtesy.
sure that was added in there.
Be on time. You both should be on time. Now, if in fact there's an accident or and the highway is closed, text the other party just as a courtesy. But yes, both of you should be timely.
Okay.
Children won't be just sitting in the car unnecessarily. And of course, during your time, you'll make sure the children get to their extracurriculars, correct, Mr. Morales, like whether it's gymnastics or whatever it is.
Yes, sir.
Right. All right. Can you both please raise your right hand to be sworn? Do you both solemnly swear from the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, Ms. Gorski, if you can briefly voir dire your client regarding this recommendation and your belief that it's the best interest of the children at this point in time, please.
Yes. Please state your name for the record.
Haley Morales.
You heard the recommendation that Ms. Brower reduced to writing and the judge read into the record.
Yes.
Do you understand it?
Yes, ma'am.
Please speak up because we're making
Yes,
record.
ma'am.
Okay, thank you. Do you believe that this parenting time is in your children's best interest?
Yes.
You understand that the court still has jurisdiction, so if it doesn't work out, something else would be better, we can always come back to court. You understand that?
Yes.
Okay, and you are committed to continuing to facilitate the relationship between the children and their father, correct?
Yes, ma'am.
Do you have any questions?
I do not.
Okay, thank you.
Mr. Morales, can you please state your name for the record?
William Ernesto Morales.
Mr. Morales, do you understand this recommendation and agreement this morning?
Yes, sir.
Do you believe it's in the best interest of your children at this point in time?
Yes, sir.
All right, do you have any questions?
No, sir.
So this will take effect, Ms. Gorski?
Today. So that
Okay.
we are, he's going to have not this weekend will be my client's weekend, and he will have next weekend. So his first weekend will be November 28th. So right now we are in week 1. So he'll have Monday next week and Wednesday and then next weekend.
Okay, so I'll make sure you're on the same page. Understand that, Mr. Morales?
Yes, sir.
Okay, all right. The court would like to thank.
Oh,
Ms.
I do have a
Brower for
quick
assisting.
question. I'm sorry, Your Honor.
ahead.
My apologies. If I was, so I have family that lives in like Findlay, Ohio. Is that an issue if I was to take them like to see my family on my time?
No.
Okay, I just wanted to make sure. I wasn't aware, and I've been told left and right from other people. I just wanted to make sure on my end.
Yeah, no problem. During your parenting time, it's totally fine.
Thank you.
All right, the court would like to thank Ms. Brower for her patience and assistance this morning. The court finds this agreement between the best interests of the children. The court will adopt the agreement, and thank you, Mr. Gorski. Mr. and Mrs. Morales, please communicate for your children's best interests. I mean, life, there's enough complications in life. Make good for each other and the children. The children sense when there's tension. You want to avoid that. Be flexible with each other. Communicate. All right. Thank you. That will conclude this matter. Everyone can zoom out. Have a good rest of the morning.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Matter of Catherine Mine versus William Mine.
For the record, this matter is before the court this morning on the plaintiff's motion for her to show cause, alleging violation of the status quo order entered by this court on August 14, 2024. This hearing is being conducted via Zoom. The president is Attorney Paul Longton, representing the plaintiff's moving party, Catherine Vine. Ms. Vine appears to be present. Mr. Longton, in addition to Attorney Stephen Rodenberg, is present, representing defendant husband William Vine. Mr. Vine is also present. Good morning, everyone.
Good morning.
Morning, Judge.
The parties have conferred this morning with Ms. Patrick, who has provided the court the following recommendation: that the defendant shall pay the plaintiff $1,500 per month commencing October 1st, 2024 for marital bills. The parties will mediate with Mr. Josh Walker on December 4th, 2024 at 1:30 p.m. via Zoom. Ms. Patrick, we can add to that the parties can appear before the court subsequent to that mediation before continuing to the pretrial conference. And if the parties are unable to reach their agreement, the court will then, if necessary, schedule an evidentiary hearing.
Yes, Your Honor.
Right. Mr. Longton, does this recommendation agree with your client this morning?
Your Honor, we object to the recommendation.
You do not?
We object to it.
Okay. All right. Okay. Let me ask Mr. Rosenberg there. Mr. Rosenberg, are you agree with this recommendation?
We're very close to agreement with it. We believe that it is slightly too high for reasons that I guess we're going to get into in a minute. So I guess the mediation recommendation, we absolutely agree with because we'd like to fast track this and get this divorce over and done with to minimize everybody's pain. But the support recommendation, we can't agree with because that would leave my client with a deficit every month. He doesn't make enough to cover that. Now we have a potential.
Mr. Rosenberg, Mr. Longton, what happened about the good old fashioned four-party meetings where the two attorneys were capable, would sit down with their clients and hash out a reasonable resolution with the guidance from their attorneys? What happened? That's in the days when this court practiced law. That's what we did. We didn't always require a mediator.
I would love to do that.
Your Honor, that's not going to happen. This case is not going to settle unless you give us a trial date. But I'm happy to tell you what my objections are to this recommendation. I think the recommendation is wrong, and if you allow me to proceed, I will.
Mr. Longton, this court will not schedule a trial date without the parties engaging in mediation. I'll tell you that right now.
All right.
I want to mediate this. I want to resolve this. And it's also my understanding that when we mediate things, it's a lot easier for everybody to live with an agreement that we come up with than one that's imposed on the bench, even if it's identical.
Well, the truth of it is we can't even agree on temporary relief. I have no confidence we're going to agree on a final settlement. But if Your Honor is ready, I'll provide Your Honor with my objections to the recommendation.
This mediation dates agree with your schedule, Mr. Longton?
Yes, Your Honor.
And I know that you wanted to mediate with Attorney Godfrey. I guess Godfrey, he's looking at next year. And you can always contact Godfrey. Sometimes he does have cancellation. So you can always ask me to put on his waiting list, Mr. Longton, and if he can meet it, because Mr. Godfrey has an incredible record in resolving matters. He has just a knack for communicating between the parties, Mr. Rosenberg. So keep an open mind. I think hold on, let me finish, Mr. Rosenberg, please. Mr. Godfrey has just a knack of being able to communicate with the parties and facilitate resolution. He does a wonderful job. It's going to save the parties a lot of money in the long run associated with litigation. So I'm suggesting that if Mr. Godfrey has a cancellation, that the two parties seriously consider that. I'm not going to order it, however, though, Mr. Rosenberg.
I just want the court to know that I love working with Mr. Godfrey, and I have no objection to working with him. My only issue is waiting till February. I want the pain to stop for these people.
Your Honor,
if that's the case, Mr. Rosenberg, then the parties should sit down and resolve it.
I would like to, but Mr. Longton seems to object to it. I'll happily meet with him face to face or over the phone or however he wants. Anytime that'll work.
Well,
I'd love to do that. It's one hand clapping at my end right now.
All right, I can do that, but again, considering we can't even agree on interim relief, I think suggesting that he and I can get together and solve this is fictitious. Now, I'm all for Mr. Godfrey. Even though he represented my wife in my divorce, I have used him since. And Your Honor is absolutely correct. He has an outstanding record for settling cases. In the meantime, I would like to address the issue of this show cause.
All right, we'll give that, Mr. Lockman. Do reach out to Godfrey because he may have a cancellation, and it'd be in the very near future, and maybe that work out. So I'm just suggesting that, Mr. Longton, because Mr. Rosenberg is not wait till February. I understand that, but reach out to Godfrey and just see if he put him on the short list for cancellations. So with that. First of all, what are the assets? What assets do we have? Why can't we liquidate some assets? That's going to relieve some of the financial pressures on the parties.
There's a house. There's a couple cars. There's I think a 401k and some pensions, and that's about it.
What's subject to liquidation? Do we have how many parts of real estate?
One.
It's a marital home?
Yes, Judge.
Okay, why does one party want to buy out the other's interest? Why shouldn't we get that house on the market? Let's liquidate it. Now is the time to get things on the market.
Yes.
The wife wants to retain the house. They have two children, although they're adults. She wants to retain the house. We can have it appraised and look for an opportunity to buy him out. Okay. Well, they get that appraisal as soon as possible, Mr. Langton,
yes, Mr. Longton, because obviously they can agree upon a value. And does Ms. Vine have the income and the resources to qualify for refinancing to get it out of William's name? I think I'll be able to steer her in the right direction, Your Honor. Okay. All right. So please move on that.
Judge, I believe she will.
Okay, but let's get that appraisal. Maybe they can both get a fair market analysis. In the meantime, rather than spend $500 on appraisal, if finances are tight, each get fair market analysis from different realtors, and maybe they can find some middle ground in terms of a value. And Mr. Vine can start that process of refinancing.
I agree.
That would be great, and that would, because a major concern that we have, Judge, is my client being put in a position where he has a recurring deficit from these obligations, and then he gets in trouble with you for violating your orders, where it's basically a matter of economic capacity, not willingness.
Right. And Mr. Rodenberg, you received the pleadings or the additional information provided by Mr. Longton regarding the monthly expenses and so forth?
I received an email last night, and we object to them because we have some of it is fictive. Some of it's legit, some of it's fictive.
All right. Okay. So the court wants to, let's establish some groundwork between now and the November pre-trial where the court can modify things. So Mr. Longton, you may proceed then.
Thank you, Your Honor. Your Honor, I submitted to the friend of the court and Your Honor their most recent pay stubs. It shows that he has a net income of $1,000 a week. She has a net income of $650 a week. So he has 70% of the income. She has 30%. Again, this is based upon his last 4 pay stubs, not something that's old. This is his most current income. He moved out of the marital residence. He moved in with his girlfriend, and I have a private investigator's report showing that he's there every night. And I can.
Mr. Longton, the court's not concerned about that. Let's just talk about finance. Let's stick to the finances.
So we're talking about
in terms of what expenses are not being met.
When he left, he gave her no money whatsoever. He's paying for the basement waterproofing, which is $150 a month, no more than that.
$300 a month.
Excuse me.
We'll have our ability to object in a minute.
Hold on.
I have the bill right here. It's $100.
I pay it every month. I paid
Mr.
it for
Vine,
the last
please
3
mute
months.
Mr.
I
Vine.
paid it
Mr. Vine,
today.
we're going to mute you.
She's
Mr. Vine.
lying.
Mr. Vine, we're going to mute you. Please mute him. You're interrupting, Mr. Vine. Totally inappropriate. So, Mr. Longton, who's paying the mortgage payment right now in default? Is it
No,
delinquent?
she's paying it. She's paying the mortgage, utilities. She's paying everything except the basement waterproofing loan. And I have the bill right here in my hand. It's $150 a month. And I can email this over to Stephen so that he can see for himself that's $150 a month.
So what are you requesting per month, Mr. Longton? $1,500 you're saying is not enough?
Your Honor, her total expenses are $5,300 a month. He makes 70% of the income. He should be paying her $3,500 a month. That's fair. So I'm not asking for any more. I mean, Your Honor signed a status quo order, which he ignored. He had 14 days to file objections. He filed no objections. He had 14 days to file a motion for modification. He did not file a motion to modify. So I think I'm righteous in asking Your Honor to consider him paying 70% of that $5,300 a month. They complain that her aged father, who's a vet, is living in the house. Well, he's living there temporarily. He's at a 1 assisted living facility. They're waiting for a VA nursing home for him. He pays for his own food. He doesn't pay rent. I was absolutely floored, and Mr. Vine alleged that he's not living with the girlfriend when my client paid for the PI, who's available by phone this morning, and he's living there all the time. In fact, what he did, he's got.
I object because this is irrelevant. Number one, my client has a First Amendment right to associate with whomever he wants.
All right, hold on, Mr. Rodenberg, Mr. Longton. The court's only concerned about the expenses per month. I don't care who's living with who and who's supporting the other person. What are the household expenses that need to be met every month? Mr. Longton, you're saying they're $5,000 a month. You're suggesting that the defendant pays 70%.
He should pay 70%, which is $3,500, retroactive to August 15th when I served him with the order.
Mr. Rodenberg, do you agree that the monthly expenses are about $5,000 a month?
No, I do not, Judge. Okay,
let's go through them. We had a mortgage of $1,200.
The mortgage I agree with, because that we
DTE.
That's too high. My client says that the DTE and the utilities average about $175 a month. And when I did a quick check online, that seems about right for a 2-bedroom house in Monroe. 5 cell phones. She's the only person on that cell phone. You can get from AT&T 4 lines unlimited for $135 a month. As for the adult children, one of them was using one of the lines on that, but he stopped doing it, and he was paying Ms. Vine for the privilege of doing it. And we believe that her father is using one of the other phone lines. We have another thing here with cable and Wi-Fi. We have double dipping here. I believe they get their cable and Wi-Fi from 2 different providers. Okay, but you can get Spectrum Basic cable for $95 a month. And I believe that would also include the internet hookup. Okay, auto insurance. One of those, okay, here we're going to go down to the cars. Her father can't drive. He bought and paid for a van that transports him to and from where he needs to be. Now, Ms. Vine also has a 2022 Compass that at the time, Mr. Vine says, just renew your lease. And she says, no, I want to buy it outright. So she decided to buy it outright. And she, instead of leasing it, that's where that comes from. The auto insurance, for 2 cars. One is her father's car. Mr. Vine, I believe, pays his own auto insurance. Amex, what's this for? $500? Is some of these billed? We don't know where the double dipping is. That's 17, that's 7. Okay, we have that. The personal care items and the clothing for herself, $250 a month. That's a lot of clothing. That's thousands of dollars a year. Even I'm not going to golden rule it, but that's high. Miscellaneous. She says $100 for what? What's the miscellaneous? We already have this Amex bill where we don't know what it's for, and there's probably some double dipping here. The timeshare has been paid for. My client got a profit sharing last year, and he works a lot less now because he works for Stellantis, so he doesn't get the hours that he used to, and it's paid off, I think, until 2025, so that's a bill that doesn't exist at the moment. The basement waterproofing, he already pays it. But if you take a look at this, what they're asking for, it's $180 a day or $65,000 a year burn rate for her. He only makes this is more than they do. He burns through about $3,300 a month for his own expenses. When he left the house and he was thrown out, he had to buy all new stuff. He had to find an apartment.
Okay.
Yes,
all right.
to pay his own utilities.
We're talking about household expenses.
Yeah, the household expenses, I believe we could resolve this. If he pays the basement waterproofing, it's about $1,000 a month. The other thing too is Mr. Was it Dykow, who is we could resolve this. If he pays the basement waterproofing, it's about $1,000 a month. The other thing too is Mr. Was it Dykow, who is the father-in-law. He's a disabled veteran, and I believe that Ms. Vine has applied for attendant care benefits, which are about $30,000 a year. So I don't even know if her finances here are accurate. One other thing, she works for a school board. She could have worked during the summertime, but she took the time off, so she intentionally reduced her income. And before filing for divorce, she also, and I know this is before any orders were in there, she removed half of the savings from their finances, so she had a lot of cash to cover all of this stuff. The problem that we have here, Judge, is she wants to live beyond both of their joint means. She wants to beggar him by making him not have any money for anything. He won't be able to pay. How is he going to pay for a mediator or for anything like that if he's paying out more than he earns? We're going to be in front of you for, I predict, for multiple show causes, not because he doesn't want to pay what you're ordering, but because he can't, or he won't be able to cover his bills. And this is all about equity and fairness. It's not about enriching the other party.
All right.
If I could respond ever so
okay.
briefly.
So
Longton,
they're asking.
hold on. The court has other matters. We're backing up in court. This is not a trial this morning. Mr. Longton, you came up with the DT of $360 a month. Have you seen the bills?
Yes, Your Honor.
Okay.
What's the breakdown on the $360 on DTE?
The DTE?
Yeah. We got.
The DTE bill is roughly $350 if you take it out for the whole entire year, because summer and winter with the gas and electric prices are very expensive.
Okay. And how many vehicles does Miss
I only
Vine
owe one.
own?
Don't talk over people, please.
What's the monthly payment? What's the monthly payment for the vehicle? Right now you got almost $600.
That's the monthly payment, Your Honor.
For one vehicle?
For one vehicle.
And that's what a vehicle that Miss Vine is leasing?
No, that it came off the lease. She bought it. Unfortunately, interest rates spiked up, Your Honor, on used cars. You can get a far better interest rate on a new car. On a used car, you can't. The auto insurance is strictly for her vehicle, $162. To suggest it's for two vehicles defies logic, because no one can get car insurance that cheap.
But she also earns money from her job. So if you take a look at this,
Could I
she's getting about
without being-
$8,000
could
a
I
month.
finish?
Hold on,
Without being
Mr.
interrupted?
Rosenberg. Yes, we're gonna have a total legitimate expenses. I'm gonna order that to Mr. Vine pay 70% of them. So we've already dealt with the mortgage, the DTE, the car payment, the insurance. We know what the cell phone. It's a pretty high bill, $350 for a cell phone. Is that we're talking about one cell phone?
Let me ask, who's on the cell phone?
Myself, my two boys, and my father.
All right, so
And he was at the beginning of the last few months that I did pay for it.
all right, so I understand if Your Honor does not want to include the whole thing.
Correct. So what is a cell phone just for her?
Cell phone just for you,
$79.
$79, Your Honor.
Okay.
Could you explain to His Honor about the cable expense of $153? What is that?
DirecTV.
Is
I
that
have DirecTV. That's the source that we have coming in, and the Spectrum is our Wi-Fi. We do not have any other option but Spectrum or DirecTV to do that in South Rockwood. I have checked into it several times.
That is not true.
Can we finish?
American
Mr.
Express.
Rosberg,
Hold
can
on,
we
Mr.
finish?
Rosenberg. American Express. And whose name is American Express though, Mr. Longton? Is
The
it in both
American
names or just in your client's name?
The American Express name was in both of our names. It was officially in my name, but it's part of the Hilton Honors Club. It's and he had his own credit card for a couple months that there is money on it.
So what is the
And,
American Express bill for? What is it, what
The
was it?
American Express bill was to pay off the Hilton Honors
All right,
And
timeshare.
the time.
is that in the name only of Mrs. Vine?
Well, he signed the papers too. They're in both of our names.
It's in both names.
Correct.
But the
Okay.
timeshare has been paid for already.
No, it
Judge.
has not.
It's not been paid.
I have that
She,
information right there.
excuse me, she handled the bills. She knows what's paid and what's not paid.
So the American Express is $500 per month, is that correct?
Yes, Your Honor, to pay off the Hilton timeshare.
That's,
So what's the balance? Is it gonna be take months to pay that off?
$8,900.
Well,
$8,900. And they make too much money to file a bankruptcy, Your Honor.
So the timeshare, is that a monthly payment or is that an annual payment?
It's monthly, and then you also have an annual payment of $1,000.
Okay, well, that's the timeshare is gonna be sold.
Yes, Your Honor. Well, I'll steer here to one of the timeshare sales.
we'd like it put on the market by the end of the week.
Okay,
Well, we'll do what we can.
waterproofing bill. What's the bounty bill?
How much is owed on the water?
I don't know, because he took. it
Judge, with the waterproofing bill, to make it simple, we will assume it and we'll ask for an offset from whatever comes on there. We'll assume that, and we'll just bake the $150 into whatever it is and then just back it out somewhere else. Because he's
Okay,
already paid it.
Well, that's fine. We can agree
Yeah,
on
but
something.
again, with the cable and the electricity and the utilities, half of that is being used by her father-in-law.
No, that's not true. He's an
Well,
agent.
he turns on the lights, he turns them off, he uses whatever. My client should not be subsidizing her family member.
He's not. He's an old guy who sits in a chair who's waiting for a nursing home vacancy.
Again, he has other children who could assume
by
that
the way, Your Honor,
responsibility. That's
does
not
not
her costs are, his
Excuse
costs
me.
are not our concern.
Excuse me, she does not receive attendant care benefits. She was not offered employment this summer. And yes, she took half the savings. Well, he kept half the savings and gave her no money towards the bills. So how is that fair? So
Well, she could have applied. The other thing too, was she wasn't offered the thing, the job. Here's the thing.
This should be retroactive to August 15th, Your Honor.
No, it
Your
shouldn't.
Honor, and I would add, Your Honor, since he has a take home of $1,000 a week, I'd ask for a temporary attorney fee because she's a school secretary.
Again, so how the heck is he supposed to pay his attorney? This is basically to starve him for money and bankrupt him. What is he supposed to do?
That's nonsense, Mr. Rottenberg.
He doesn't have enough money to do this, and we shouldn't be enriching Mr. Longton. So
Based upon
like he was
based
talking about
upon
on
the
the
court's
open mic.
calculations of the appropriate monthly expenses and the incomes of the parties, the court will order that the defendant pay $2,000 per month to the plaintiff, commencing October 1st, 2024.
You can't, Judge, we're gonna have to object to this because he doesn't have money.
Go to the Court of Appeals, Mr. Rohenberg. Miss Vine will pay those marital expenses, but Mr. Vine will pay the timeshare and the waterproofing bill. He's already paying those, so he'll continue to pay those. And the other bills we paid by Miss Vine, and Mr. Vine shall pay $2,000 per month. The price will meet at December 4th, 1:30. And subsequent to that, appear before the court for a continued pretrial conference. If necessary, we'll schedule an evidentiary hearing that time. Court's also suggesting, once again, Mr. Long can reach out to Attorney Godfrey. Maybe he's got a cancellation.
I will, Your Honor. I missed the settlement conference date.
Miss Patrick, if you could please modify the recommendation. Let's take into account the appropriate expenses on a monthly basis and the incomes of the parties, $2,000 per month, October 1st. So, Mr. Vine, you need to make a forthwith payment to Miss Vine. I don't know if you do by Venmo or do you want to give her a check or electronic transfer. You need to decide that, but
Judge, I'm going to say on the record, I don't think he has the money.
Okay. All right. That will conclude this
hearing. He
hearing.
has the money.
He's got to make it happen. That's the order of the court.
Your Honor, should this be through income withholding?
Ms. Patrick, I don't think so because it's not spousal support or child support.
That's correct, Your Honor. It cannot be through withholding because technically it's a property issue, not.
All right. Thank you, Your Honor. Thank you.
And
Mr. Patrick, are there any sooner mediation dates than December 4th? Nothing available in November?
There was, Your Honor, but I believe Mr. Longton needed some time. He had just sent out subpoenas, but yes, we have dates available in November.
We need the subpoena information on pensions and et cetera in order to do this.
All right. Okay. All right. So we'll see everyone after the December 4th mediation. And if we need to fine tune this financial obligation on the part of Mr. Vine, at that time we can do that.
okay.
And the settlement conference is when, Your Honor?
After the December 4th, 1:30 mediation, whenever you're done.
Okay. All right. Thank you.
All right.
Welcome. If you could add that to the recommendation, Ms. Patrick, the party shall appear after the mediation for a pretrial conference, please.
Yes, Your Honor.
All right, that concludes the matter. We can zoom out. Have a good rest of the morning.
Thank you, Your Honor.
Bye.
For the record, this matter is before the court for a continued pretrial conference subsequent to the parties engaging in mediation with Joshua Walker from the front of the court. This hearing is being conducted via Zoom. President Attorney Paul Longton, representing the plaintiff, Catherine Vine. Ms. Vine appears to be present with Mr. Longton. In addition, Attorney Stephen Rotenberg is present representing the defendant. William Vine, Mr. Vine appears to be present with Mr. Rotenberg. Good afternoon, everyone.
Good afternoon, Your Honor.
You judge can answer.
The court has been informed that the parties have reached their own agreement. Is that correct?
Yes, Your Honor.
Wonderful. Who would like to place agreement on the record?
I can, Your Honor, I believe.
Please, Mr. Longton.
If Josh is not doing it, I can do it.
Please, Mr. Longton.
All right, Your Honor, it's agreed that the house will be deeded to the plaintiff's wife. She'll assume the mortgage, hold the defendant harmless. She'll refinance it to remove his name within 90 days of entry of the judgment. The husband, as a quid pro quo, will be awarded his 401k. Wife will retain her 401k if she has one. There'll be a quadro entered regarding his pension plan. She'll receive 50% of the marital portion with a proportional share of all the usual benefits, including early retirement subsidies, cost of living, etc. If she has a defined benefit plan, he'll receive 50% of the marital portion of that. We're not sure whether or not she has a pension as a school secretary, but we're going to find out. As far as personal property, each person has the personal property they want in their respective possessions, so there's nothing to divide there. The gentleman is awarded his Ram pickup truck. The spouse is awarded her vehicle, which is a 2022 Jeep Compass, which has a loan. She'll assume that and hold him harmless. There are two debts. There's a basement waterproofing loan in the defendant's name, which he's going to continue to assume and pay and hold her harmless. She has a American Express account with approximately $9,000 owed. She'll continue to pay that and hold her harmless. She'll receive the I'll call it a timeshare, but it's a point system with Hilton Honors, whatever it is. She'll be awarded that because she's paying that debt, and she'll have to pay the annual fee and hold him harmless. So I've covered the two debts that are important. The house to her. I've covered the two pensions. He's going to keep his test fee, or whatever it is with Stellantis. He's going to pay how much a month? Going to pay her $1,100 a month in non-modifiable spousal support, commencing December 1st, 2024, continuing for 5.5 years, again non-modifiable. There is a temporary order, which Your Honor signed in September, ordering him to pay $2,000 a month to her on the 1st of each month. We understand that based upon what Mr. Walker told us, that he has sent her a check for the $2,000 for November. If that's true, he'll have no arrearage because this new spousal support will commence December 1st. If he did not pay her the $2,000 for November, then he would owe that, and that would be payable forthwith. He's also going to pay to my office tomorrow a sum of $4,000 over the phone by credit card. If he does not pay that tomorrow, then we agree that the spousal support will commence January 1st, 2025, and then he'll owe her $2,000 for the month of December under the temporary order. If I could have just a moment, I want to make sure I'm not leaving anything out. I don't believe there are any other joint debts. If there are any other joint debts, I would like counsel to bring that up when it's his turn to speak. There's no other award of attorney fees, no other obligations on the part of either party. Have I left anything else? That was reminding me about something. I believe that's the total agreement, but I'll leave it to Mr. Rottenberg to correct my recitation if it's wrong.
The only one that jumps out.
Hold on just 1 minute. Just a question, Mr. Longton. With respect to spousal support, you indicated $1,100 per month, non-modifiable in terms of amount or duration. Is that correct?
Correct. For 5.5 years.
The duration
non-modifiable as to amount and duration for 5.5 years.
We thought we pay this. If it came up, we could do a lump sum because it's a fixed amount. So if, let's say, 2 years from now, he decides to pay off whatever's left, I don't really think that we should have an objection to that.
No, of course not. Of course not.
Right. Okay. All right. The other thing too is I'd like to give a clarification because I believe she has a 403B, possibly not a 401k, because she works for a government entity.
Correct.
And I have just said one other thing. My client's just scribbling something down, so I need to figure out what he's.
But part of the agreement was she would keep her 403B. He's going to keep his 401k.
Right. Yeah, I was doing it for clarification, not or correction, not to make additional claims. What do you want?
Can the spousal support be set to be paid on the middle of the month?
Can we set the spousal support to be paid around the 15th of the month?
Well, we typically want to do it by an order of income withholding, and what they'll do is if he's paid twice a month, then they'll take it out twice a month. So he'll have what he wants.
All right.
Okay.
That'll work. The only issue then being if we do an income withholding order, there might be a little bit of a delay in the system.
Of course.
So I don't want him to be penalized for that
That's fine.
or show cause for that.
But she'll have to be patient. Thank you.
Thank you.
So Mr. Rosenberg, other than those clarifications, did Mr. Longton accurately state your client's agreement?
Yes, I believe so.
Yes.
And with respect to spouse support payments, Mr. Vine should look to see what's coming out of his paycheck. If it's not coming out of his paycheck, he should pay that directly by check, or let's have some documentation to verify that payment. He shouldn't wait the 2 or 3 months before that takes effect.
Right.
Income withholding order.
My client wants to ask a question. Just a sec, Judge.
Judge, does it have to be done that way, or can I pay her monthly? And if she doesn't receive it, then if she wanted to show cause me, I can do that too. But that way I know it can be done through certified.
Sure, you can do electronic transfer into her bank account the 15th of every month if the parties agree upon that. You can then always she can opt into the front of the court if she's having trouble, and we can do it by income withholding order. So yes, you can pay it directly if the two of you agree.
It's up to her. I would agree to that, but it's up to
Your Honor, she would prefer to have the order of income withholding because he's not been timely in paying under the temporary order.
Okay.
Judge, he paid the first thing 4 days after you ordered it to him. He's paying it as quickly as he can. So I wouldn't say he's not been timely.
Okay, but if the plaintiff requests that be through the front of the court, so be it. That's what it'll be.
Okay.
I'm good with it.
And it might be easier for Mr. Vine to take and make 2 payments per month rather than 1 lump sum. But until it comes out of your paycheck, Mr. Vine, you should pay that directly to Ms. Vine so you don't have a significant arrearage. Wonderful. All right, Mr. and Mrs. Vine, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. Mr. Longton, we took the proofs back on October 15th. If you can just verify with Ms. Vine that she's currently not now pregnant, then you confirm with her in terms of this agreement, please.
Sure. Ma'am, are you currently pregnant?
No, I'm not.
Okay. All right. She's smiling, Your Honor.
Thank you.
You understand that by agreeing to the non-modifiable spousal support, you're actually waiving your right under Michigan law to have the court consider modifiable spousal support with no end date. You understand that you're waiving your right to that.
Correct.
You understand that your waiver is final and binding.
Correct.
And then if you become ill tomorrow or get in an accident, you can't come back and ask for a redo. You understand that?
Correct.
You understand that the $4,000 that your husband is paying to my office tomorrow will be credited to your attorney fee account. And if there is any credit balance, that'll be refunded to you.
Yes, I do.
And you agree to that?
Yes.
Now, do you consider the property settlement fair and reasonable?
Yes.
You understand you have an obligation to refi that house within 90 days?
Yes.
And to remove him from liability?
Yes.
All right. Your Honor?
Thank you, Mr. Longton. Do the parties want to get divorced in 2024 or will it be submitted after January 1st?
I think she wants to be divorced in 24, Your Honor.
Okay. All right. And you'll prepare the judgment, Mr. Longton?
What about tax? How do
Prepare the judgment, Mr. Longton?
need to worry about it?
I'll prepare a judgment, Your Honor.
Thank you. Mr. Rosenberg, do you have any questions? First of all, from Miss Catherine Vine.
Ms. Vine, is this an agreement that you reached on your own with your attorney?
That is correct.
And nobody made you any promises or threats or anything like that to reach this?
No.
And you realize that you could have gotten a different result, better or worse, or possibly the same had you gone to trial?
Yes.
And you realize that by having the settlement agreement, you give up the right to confront witnesses, call witnesses, or basically have a trial.
Yeah.
Okay. Are you
Mr.
happy?
Rosenberg, questions for-
Are you happy with your lawyer's representations?
Yes.
No further questions of Ms. Vine.
All right, Mr. Rosenberg, questions for Mr. Vine, please.
Yes. Okay, Mr. Vine, is this an accurate recitation of the settlement?
Yes, it is.
And did you reach it on your own without you decided this yourself, right?
100%.
And nobody made you any promises or threats or arm twisted you in any way to get here?
No, sir.
You realize that by breaching the settlement, you give up the right to a trial.
I do.
And you realize you give up the right to confront witnesses or subpoena evidence, etc.
I do.
Are you satisfied with my representation?
I am.
Do you have any other questions for the court?
I do not.
Okay.
Thank you, Mr.
I
Thank you,
guess
Mr.
maybe I
Rosenberg.
Hang
do.
on.
I guess maybe I do have one quick question. So the divorce will be final in 2024, but for income tax purposes for 2024, what typically or normally is done on this? Are we
Be married, filed separately.
okay? I'm good
Mr.
with
marital status as of December 31st. So if you're divorced and before December 31st, you file separate, not married,
Okay.
but separate. Single
okay.
and separate. If you,
I just have one question for Mr. Vine.
Yes, sir.
go ahead, Mr. Longton.
Sir, our office closes at 4 p.m. each day, so when you call the office tomorrow, you have to do it before 4 p.m.
Hey, Mr. Longton. So
Yeah.
I'm okay to call the office in the morning and then I can give you the numbers that you guys need.
That's excellent, thank you.
And for the record, my client has my permission to contact Mr. Longton's office directly
Thank you.
and discuss this.
Right, thank you. So Mr. Longton, you'll prepare the judgment. You'll get that to Mr. Rosenberg for his review and approval and that of his client. And if he submit it before the end of the year, the court will sign it. So that's the intent, Mr. and Mrs. Vine, is for the court to receive that judgment, sign it yet this year. So you're divorced before the end of the year.
Your Honor, we will submit it to Mr. Rotenberg no later than Friday for his review and correction.
Thank you. Very well, the court would like to thank and acknowledge Mr. Walker for his assistance in helping facilitate a resolution, as well as, of course, attorneys Rotenberg and Longton. And the court would applaud you, Mr. Vine, for reaching your own agreement. Without question, the best resolution is one in which you both participate, as you have this afternoon, and reach your own agreement. Far better off than a trial before this court. Based, however, on the testimony that's been presented today, as well as previously, and as well as complaint filed in this case, court finds again that jurisdiction's been established. There's been a breakdown of the marriage. There's no chance for reconciliation. Accordingly, upon receipt of the consent judgment approved by the parties, the court will sign that judgment. And at that time, the court will order that the marriage between the parties be dissolved, and the judgment shall enter granting a divorce from the bonds of matrimony. Good luck to both of you. I guess one last question, Mr. Longton. Does Miss Vine want a former name restored, or maybe I missed that?
He does, Your Honor. It's Dykow. She wants her former name restored. Thank you for asking.
Okay.
Yes,
All right.
thank you, Judge. I appreciate you asking that. I'd forgotten all about that.
Okay. All right. That will conclude this matter. Thank you again, Mr. Longton and Mr. Rosenberg, and good luck, Mr. and Mrs. Vine. You can zoom out and have a good rest of the afternoon.
Thank you.
Thank you.
For the record, this matter is before the court for an adjourned hearing on the defendant's objection to a referee recommendation regarding custody and parenting time. This hearing is being conducted via Zoom. President is Attorney Leslie Carr, representing the moving party, Zelius Morrow. Mr. Morrow is present. In addition, plaintiff Mother Taylor Jenkins is also present. Good morning, everyone.
Morning.
Your Honor.
Parties have conferred this morning with Ms. Brower from the front of the court, who's provided the court with a fine recommendation. The recommendation is that the referee recommend order be modified, adopted but modified as follows. Namely, the parties shall share joint legal and joint physical custody of minor children. Parenting time shall be as the parties can agree upon, with the parties' intent to share equal time with the minor children. The parties shall exercise parent holidays as agreed. Defendant fellow shall pay child support in the amount of $600 per month. In addition, he shall pay the child support directly for the month of November 2024 and pay the child support through the front of the court effective December 1, 2024. Uninsured medical expenses shall be divided between the parties 50-50. That is the recommendation. Ms. Carr, is this recommendation agreed with your client this morning?
Yes, it is.
Thank you. Ms. Jenkins, do you understand the recommendation?
Yes.
Have any objection to the court adopting this recommendation?
No.
Wonderful. Just one inquiry. If the parties cannot agree on holidays, perhaps we should put in here that the fallback will be the front of the court holiday schedule. You can maybe add a semicolon to Ms. Brower that if parties unable to agree, then the front of the court holiday schedule shall apply. So we're not coming back to court. So you can look at the Friendly Court holiday schedule, you can get that online, and that might give you some guidance, because if you cannot agree, that's what what's going to be the fallback.
Okay.
All right, Ms. Card. All right, let's take some brief testimony. Mr. Jenkins, Ms. Marorrow, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give us now will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. Ms. Carr, if you could briefly word to your client and confirm that you believe it's the best interest of minor children to adopt this agreement, please.
Yes, thank you, Your Honor. Mr. Marorrow, could you please state your name for the record?
Yes, Zelius Marorrow.
And Mr. Marorrow, you heard the agreement that was placed on the record, correct?
Yes.
And this was an agreement that you and Ms. Jenkins came up with on your own, is that correct?
Yes.
And you understand all the terms and conditions?
Yes.
And do you believe that that agreement is in the best interest of your minor children?
Yes.
Thank you, Your Honor. I have nothing further.
Thank you. Ms. Jenkins, can you please state your name for the record?
Taylor Jenkins.
Ms. Jenkins, you participated in the discussions this morning with Mr. Marorrow and Ms. Carr and Ms. Barr from the front of the court. Is that correct?
Yes.
And as a result, you've reached this agreement. Do you believe this agreement to be in the best interest of your two children?
Yes.
Do you have any questions for the court?
No.
All right. Ms. Carr, do you have any questions, Ms. Jenkins?
No, I do not.
All right. Thank you. Thank you, Ms. Barr, for your assistance. The court finds any agreement of the parents to be in the best interest of minor child and children. The court will only adopt this agreement. The court applauds you, Ms. Jenkins and Ms. Barr, for reaching your own agreement. You know what's best for your two children. There's enough challenges in life, so make it good for each other and the children. In terms of communication is the key. Your children will do well in life if they know there's not tension and animosity between the parents. So work together for their best interests. And if you need to modify things, be flexible with each other. Work together, especially as children get older and they're involved in more activities. So with that, the court will adopt the recommendation. You can all zoom out.
Thank you, Your Honor.
Thank
You're
you.
welcome.
Thank you.
For the record, this matter is before the court on the respondent, Jordan Gotchock's motion to terminate personal protection order. This hearing is being conducted via Zoom. Present is Attorney Timothy Churchill representing the respondent, Jordan Gotchock. Mr. Gotchock appears to be present. Mr. Churchill. Is Brad Schill present on audio?
I am.
All right. Good afternoon, Mr. Schill.
Oh.
Before we begin, the court had a couple of questions, and I don't know if both of you perhaps can address this. I believe in Mr. Schill's petition, he alleged that there was a forensic interview of the minor child on August 28th, 2024, and the Michigan State Police were involved. Any updates on that?
So far, no. And I've not heard back yet. The only thing I was told that they were able to tell me is that it is an active, ongoing investigation.
Okay, that's Mr. Schill making that statement. Mr. Schill, did the forensic interview take place on August 28th?
It did.
A forensic between the minor child and the Michigan State Police, is that correct? Or was that
correct?
All right. That's 2 months ago.
When we initially filed the report, we were explained to that it is a lengthy process, and he couldn't stress the lengthy part enough, insinuating that this is going to take quite a while. Why, I don't understand. I'm not sure. So.
Okay. Okay, Mr. Churchill, and your petition, you allege that some issue of improper service. We're going to get past that. You also allege that the petition falsely states that the responding has a pending charge. Obviously, there is no pending charge. There is an investigation. And I understand there is obviously interplay between various family members. But obviously, the court wants to protect a child. And obviously, it seems like when there's still pending investigation, that Mr. Gotchock should not have any contact with his child. Is that an issue?
No, and I don't believe there's been any contact for at least 10 months with this child.
All right. So maybe it's just a matter of simply modifying the personal protection order. Obviously, the this minor child that lives with you, Mr. Schill, is that correct?
Yep, she's my daughter.
Oh, your daughter,
on the-
okay.
Yep, on the paper that I was served, it has our relationships down incorrectly. I'm not a former boyfriend. That's my wife. I'm her husband, and Olivia is my daughter. And the sole purpose of filing for this PPO, I don't know if you remember speaking to me face to face at your window, is just to have something legal in black and white to make sure he can't come near. That's it.
I do not recall speaking with you at the window, but if you're a petitioner, I probably told you whether I was going to grant it or not. But in any event, Mr. Churchill, does your client agree that, does he have any objection to avoiding contact with this minor child at this point?
Well, Your Honor, he has not had any contact with that child for at least 10 months.
I understand. That's not the question. Does he have an
Yes,
objection to
however,
not having
he's
contact
very-
in the future?
No, he has no intention to have any contact with this child, especially after an allegation like this has been made. But it's unfair too, because he's never engaged in any kind of sexual conduct or contact with this child. And it is of record and people can find out about this. It affects his right to hunt or do anything of that nature. Furthermore, his sister-in-law made a similar complaint about the same day, and CPS totally investigated that one and did a 12-page report that there was no sexual abuse found whatsoever. And it references in that report about the complaint that he had made in the PPO. So he's been cleared on the one investigation regarding his own children. And now he has to deal with one concerning his wife's sister that he made.
Court's trying to grasp this whole relationship between sisters and spouses and so forth. But obviously, Mr. Schill, Mr. Churchill has a good point. Obviously, these are pretty strong allegations suggesting that Mr. Gotchock had some inappropriate sexual contact with your daughter, Olivia. And again, it's all based upon hearsay. Obviously, the court will always take initial efforts. The courts can give everyone the petition the benefit of the doubt and issue a protective order for that child's benefit. But obviously, these allegations are technically based upon hearsay. It's just what you've been told. We don't usually involve the minor child. If in fact there is a criminal charge authorized, that criminal court will without question will impose bond conditions of no contact. Mr. Gotchock has indicated he has no desire to have any contact. Again, obviously, the court suggests Mr. Gotchock stay away. Don't be, if they invite you over for Christmas or Thanksgiving dinner, you want to avoid any contact with this minor child, Olivia. Can your client do that, Mr. Churchill?
Well, yes, Your Honor, and he's going through a divorce right now too. He's not even with his wife anymore, would have no reason to have any contact with any of her family members, because that's his sister-in-law that's made this complaint.
Okay.
That he's using as a basis for his PPO based on multiple levels of hearsay.
Well,
Your Honor, if I may.
Go ahead, Mr. Schill.
That's actually incorrect. I filed the PPO on behalf of my daughter, and I filed the police report on behalf of my daughter before Jordan's soon-to-be ex-wife or children did anything. The trooper that came out decided to wrap it all into one, but I was the initial filer of the complaint or the report. I'm not very close with that family, my wife's family. I mean, to me, it's completely and totally irrelevant what they're doing, what they're going through. I don't go out of my way to speak to them or visit them. I have my own children, my own life. I lost my job over this. If you could have been there to witness my daughter speaking with the police, there's not a doubt in my mind. And it took quite a while for us to even proceed with filing the report. I mean, I don't know what else to say.
Right. There's no question, Mr. Shell, you have to act in the best interest of your child, your daughter. No question that she's too young to file a petition for a PPO. She's too young to file police reports and make all these. But the court cannot ignore the fact that the complaint was made 2 months ago and there's still no action taken. Actually more than 2 months, but the forensic interview took place 2 months ago and there's still no action taken by law enforcement. Usually doesn't take that long. But the allegations you presented, the court will always act upon there, and there's no doubt in this court's mind you made these allegations in good faith. But when it comes down to it, it is hearsay. You're just you're alleging what you've been told. So absent unless we had some testimony from a trooper that's doing the investigation or some criminal charges, the court has no alternative but to grant the motion. To terminate the PPO because it does adversely affect Mr. Gotchock. He can't go hunting. He loses his right to carry a firearm. But the court would suggest, Mr. Schill, if in fact he has contact with Olivia, you come back before the court. So the court's suggesting, and Mr. Gotchock's listening, Mr. Gotchock void like the plague any contact with Olivia. If you have any contact with her, the court's going to enter this personal protection order. It's going to be long term.
You got it.
It's going to be a basis for this court to reconsider this if you have contact with her. So simply, I would suggest that you comply with all the terms of this order, even though the court said terminates it. Don't enter into the property where she lives. Don't go to Petersburg. Don't follow her. Don't, if you see her in the store, you run the opposite direction. Just to avoid any contact. No text message, no emails, no contact with this minor child. You understand that, Mr. Gotchock?
Yes, sir.
So, Mr. Schill, I regret, but again, Mr. Gotchock, if it comes to your attention, he's having any contact directly or indirectly with Olivia, you come back before the court will enter another personal protection order to prohibit that type of conduct. If in fact there's any criminal charges authorized, come back before the court, but I'm totally confident any criminal court will impose a condition of no contact without question. That's pretty standard, pretty routine. But based upon the fact that the allegations are hearsay, the court really has no alternative but to then at this time terminate the personal protection order. All right, anything further this morning, Mr. Churchill?
I just want to indicate, Your Honor, the similar and almost same complaint that his sister-in-law made was made 2 weeks before he filed this. And this matter was thoroughly investigated, including by Detective Peterson, and they did not authorize any charges and concluded there was no form of sexual abuse whatsoever found as a result of this investigation. And it's a 13-page report. So I don't know what the status of the other matter is, but I'm assuming that this dealt with all complaints that the state police had before him at that time. So, but regardless, I thank the court for terminating this. It is predicated solely on hearsay. And the most bothersome thing is here, he signed under oath there were charges pending at this time, and there was never any charge pending. Pending charges, it says, see attached. The attachment is, its first lists his wife's name on it. He crosses it off and puts his name on it. So I think there's other shenanigans going on here, but nevertheless, I thank the courts for its decision today. And trust me, my client has no desire to have any contact with Olivia, and certainly not with her father.
Right, Mr. Churchill, there were no attachments in the court file. I do see that it references attachments, pending charges, but there were no attachments attached to this petition, so there's nothing in the court file.
And he signed it under oath that everything in there was absolutely true under the penalty of perjury.
Understood.
People should be cautious when they sign things under oath like that because there's never been a pending charge. If you ask me, he committed perjury when he signed it, but I thank the court for its decision.
All right, Mr. Show's a lay person, and the court, so your points understood, Mr. Churchill. All right, Mr. Show, again, you'll be mailed a copy of this if in fact it comes to your attention that Mr. Gotchock is trying to reach out to or initiating contact with Olivia. You come back and file this petition. The court will grant that. So, and hopefully Mr. Gotchock will avoid at all measures any contact with Olivia. And again, obviously, Trooper Peterson, it's not like he's concluded his investigation. Mr. Churchill, you have a copy of the report? So maybe,
Yes, I
maybe
do.
Mr.
It's a
Churchill follow up with
14-page
Detective Peterson,
report.
ask for a copy of his report, because obviously he's issued a written report. Mr. Churchill has a copy of that.
The last time I spoke to Detective Peterson, he told me that he had concluded his portion of the investigation and that any further reaching out would go back to Trooper Enders. And the only thing that I have from Trooper Enders is a business card with an initial report number. And every time that I've spoken to him, that's all he's told me is that it's still under an investigation. I mean, I guess I'm just very confused at this point. All in all, I can appreciate everything. My ultimate goal is no shenanigans. I live a quiet life. I think it's pretty obvious at this point. I didn't confront him my own self for a lot of reasons. I just tried to do things the best way that I could think of. Ultimately, the end goal is to make sure my daughter and Jordan Gotchock never come face to face ever again. That's it. I don't care about his reputation or any of that business. Irrelevant to me. That's my daughter. I'm her father. I just want to keep her safe. What would you do for your own child? That's it.
Absolutely.
All I got to say.
The court fully understands that, Mr. Shell. It's a point well taken. But I, of course, you just follow up with Trooper Peterson. He's the one that handles in Monroe County cases of the allegations of this nature. Follow up with him and just ask, has he turned anything into the prosecutor's office? I mean, if in fact he's closed the investigation, so I'd suggest follow up with Trooper Peterson. He'd be the best person to provide you with an answer exactly where things stand.
Okay, I'll do
that. It could be that he's turned everything over to the county prosecutor. It could be sitting, being reviewed by the county prosecutor to say, we don't know. But I would suggest talk with Trooper Peterson. He can give you the answers to those, and absolutely had every right to protect your daughter. And yes, the court's always, out of abundance of caution, will always enter orders of this nature. But the reality, Mr. Gotchock has challenged it, and it is based upon hearsay. For that reason, the court will terminate the personal protection order. All right, the copies are already mailed out to both of you, and now concludes hearing. You can post them out. Have a good rest of the morning.
Very well.
Thank you, you as well.
Honor.
For the record, this matter is before the court on the plaintiff mother's objection to a referee recommendation of child support. This hearing is being conducted via Zoom. Good morning. Are you Jax? Said Valier? Is that pronounced correctly?
Yes, actually. Thank you.
Right. Good morning. Is Austin Gregoroff present on audio?
Your Honor, he has not appeared this morning.
Thank you. Miss Van Leer, did you in fact mail a copy of this?
Yes.
Objection and notice of hearing to Mr. Gregoroff?
I mailed it to the address that's on my papers, yes.
Okay. Do you know if he lives there?
I have no idea. I know
So
that that's where they send his mail, and he did show up for the DNA test. So I would assume it's a good place to reach him.
Was it returned to you as being undeliverable?
No.
Right. And that's the address that the front of the court appears to have on file. 58, correct, Miss Brower?
Yes. Yes, Your Honor.
All right. The court would note this matter was scheduled for at 11:15. It's now 11:50 a.m. The defendant having failed to appear. And Ms. Valier, the recommendation this morning, I can't tell you either how the front of the court secured your income information, but I'm sure Ms. Brower explained it to you. But in any event, the recommendation is that rather than Mr. Gregoroff paying $0, he will pay $99 per month effective November 1st, 2024. So the referee recommendation order is modified to reflect $99 a month payable to you for commencing November 1st. Do you understand the recommendation?
Yes.
Objection to the court adopting the recommendation?
Yes.
Okay, what is your objection? You think he should be paying more?
No, I think $99 is fine. I mostly just was concerned about my income being corrected since she's on state insurance.
Okay, and you've corrected that, and so you're agreeable with the recommendation, correct?
Yes.
All right, the court will adopt the recommendation. Copy will be mailed to you, Mr. Gregoroff. That will conclude this hearing. You can zoom out and have a good rest of the afternoon.
Thank you. You as well.
Thank you, Ms. Brower.
You're
I
welcome.
can
Judge,
hear
you
you,
should
but I
have.
don't know how to do Zoom.
No, you're in Zoom.
Oh, you can see me?
No, but we can hear you. That's all we need.
Oh, okay, perfect.
So you're good.
Okay, thank you so much. So what do I do, sit tight?
Yep, Judge will be out in just a minute.
Okay, I hope my phone don't die. Thank you.
The matter of Zachlina Tabor versus James Tabor.
For the record, this matter is before the court on the respondent, James Tabor's motion to terminate a personal protection order entered by this court on October 7th, 2024 in favor of Zachlina Tabor. This hearing is being conducted via Zoom. Ma'am, could you please state your name for the record?
Zachlina Tabor.
All right, good afternoon. Is James Tabor present on audio?
Yes.
All right, good afternoon, both of you.
Good afternoon, Your Honor.
The two of you recently had a pending divorce action in this court, is that correct?
It's very hard for me to hear you.
Is it true that the two of you recently had a pending divorce action in this court?
That's correct. I dismissed it.
Okay, but you want to keep the PPO in place, is that correct, Ms. Tabor?
No, I do not.
Okay, so you're asking this court to grant the request of James and terminate the PPO?
Correct.
Did you say to terminate?
Yes, this is a question for Zachlina. James is asking to be terminated. Are you likewise joining in that request to terminate the PPO?
Yes.
Yes, Your Honor.
All right, this question is not for you, James. I know you filed a motion. I know you want to terminate it. The question is your wife also agreeable with that?
Yes.
All right, and then Mr. Tabor, has anyone promised you anything? Or has your husband threatened you in any way in order to get you to terminate this PPO?
No.
The court is reluctant to terminate these PPOs, but due to the fact that you've dismissed your divorce action, you're attempting reconciliation, the court will grant the request of James since the petitioner is agreeable. All right, do either of you have any questions for the court?
No.
No, Your Honor. Sorry about that. I can't see on my video phone and it's hard to hear. So my apologies, Your Honor. Thank you very much.
We can hear you. The court will enter order today. It'll be removed from lien. You'll both be mailed a copy at the same address. We have an address, correct?
Correct.
Yes.
All right. Hopefully you can work through the issues. Well, you can engage in counseling, work through the issues so you can maintain your marriage relationship. You're not before the court on matters of this nature. All right. The court will enter the order terminating the PPO. That will conclude this matter. You can both zoom out. Thank you for appearing to let me know this afternoon.
Thank you.
Because you saw her versus Marcus McGee.
For the record, this matter is before the court. Subsequent to the parties have engaged in mediation with Mr. Walker from the front of the court. It appears we have both parties present. You are Mackenzie Stahl, is that correct?
Yes.
Ms. Stahl, can you hear the court?
Yes, Judge. Can you hear me?
There you are. Okay. Good afternoon. And sir, you're DeMarcus McGee.
Yes, Your Honor.
Right. Good afternoon. Mr. Walker, have the parties been able to make some progress on their own agreement with your assistance?
Yes, they have, Your Honor, and I have put their agreement into writing, and it is in your queue as a recommendation.
Thank you. One moment, let me access that, please. Well, Ms. Stahl, Mr. McGee, the court's received the following written recommendation from Mr. Walker. Is that parenting time be as specific as follows? The party shall alternate weeks in the summer. Week on, week off with exchanges on Sundays at 7 p.m. Father's first week of parenting time during summer shall commence the Sunday after school gets out. And thereafter, week on, week off. Holidays shall be as follows. The parties shall split the winter break in half. The Thanksgiving holiday shall commence the Tuesday before Thanksgiving every year. In even years, fathers shall have Thanksgiving and the second half of winter break. Mother shall have the first half of winter break, and then odd years, father shall have the first half of winter break. Mother will have Thanksgiving and the second half of winter break. All other holidays not specifically listed herein, namely the winter and Thanksgiving, shall be according to the party's regular parenting time schedule. Find that any prior orders not inconsistent with this order shall continue in full force and effect. So you've simply modified parenting time that works with both of you. Ms. Dahl, is this the correct statement of your agreement?
Yes, Your Honor.
Okay. Mr. McGee, is this the correct statement of your agreement?
Yes, Your Honor.
Wonderful. Can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, Your Honor.
Thank you. Ms. Dahl, please state your name for the record.
Mackenzie Stahl?
Thank you. Ms. Dahl, do you believe this agreement to be in the best interest of your child?
Yes, Your Honor.
Wonderful. Mr. McGee, please state your name for the record.
Marcus McGee.
Same question to you, Mr. McGee. Do you believe that this agreement is in the best interest of your child?
Yes, Your Honor.
All right. The court finds any agreement between the parents to be in the best interest of minor child. The court would like to thank Mr. Walker for his fine assistance. The court will adopt the agreement. And the court applauds the two of you. I mean, it's wonderful. Your child will benefit and thrive because you're on the same page. And obviously there'll be challenges in the future when your child gets older, involve more activities, but effective communication is the key. There's enough challenges in life, make it good for each other and your child. Your child will thrive if he knows there's no animosity and tension between the parents. So I sincerely applaud you for reaching your own agreement. The court will adopt this agreement and copy mailed out to both of you. So good job. Thank you again, Mr. Walker.
Thank you, Your Honor.
Welcome, everyone.